kung saan po ako graduate. Marami po siyang tinanong. Why did the Chief Justice declare 2:1? Why did the Chief Justice put the real properties under the names of his children? But the question is not why. The question is why not? Why not did they choose not to cross-examine him and pose these questions when he was here? The man presented himself before this court. He could have responded to all these questions, but they chose to waive. What is the effect of the waiver? Our rules are very clear that when cross-examination is waived, the testimony of the witness is unimpeached. It remains on record. The issue now here is his credibility. Let me bring this situation in its proper context. Every person is presumed to be innocent unless proven otherwise. That is very clear. I need not cite my basis for that because that is inherently natural in any system of government. The burden of proof in this case, it is also very clear. It is upon the prosecution. And if it fails to satisfactorily show the facts upon which they base their claim, the defendant is under no obligation to prove his defense. And if the prosecution fails to establish any of the elements necessary to constitute a crime, Chief Justice Corona is entitled to an acquittal. Let me go briefly to what they tried to prove. They tried to prove that the Chief Justice did not declare his assets in his SALN. They have presented witnesses, documents, but everything has been explained. It has been shown that the real properties which they wanted to prove were not really 45. It was only 5. And it was also shown that all 5 have been reported in the 2010 SALN. Are we going to trivialize this by saying that parking lots have to be included when in fact we know that the accessory follows the principal? We don't have to go to this anymore. Are we going to even go into the timing of when the chief should have reported this? Should it have been in 2008 or 2009 or 2010 when in fact witnesses here have testified under oath that the Chief Justice had issues about the unit? The Chief Justice was at the very least in good faith. That to me is very clear. Again, they have pounded the Chief Justice on his dollar accounts. They have said, inamin na niya. He already said that he has $2.4 million. What else is there to prove? As if the foreign currency deposit law does not exist. First of all, how were they able to prove this? This was proven through the testimony of the Ombudsman, which, with all due respect, in my opinion as a lawyer, is hearsay. The AMLA officer who prepared that report was never presented in court. That AMLA officer was never made to explain the entries that he made there. The AMLA officer was never presented to show the supporting documents that he relied upon. What did the Ombudsman say? Hindi ko naintindihan yung AMLA report. So what did I do? I called the COA to explain to me the AMLA report. Of all the people to call the COA, why did not she call the AMLA? They were the ones who prepared the report. Bakit hindi silang pinagpaliwanag? And I propose an answer to these questions. The answer is very simple. The AMLA refused to testify because there was no court order allowing that inspection. That is very clear under the law. Authority to inquire into bank deposits, Section 11. The AMLC or the AMLAC may inquire into or examine any particular deposit or investment with any banking institution or non-bank financial institution upon order of a competent court. Did the Ombudsman ask the AMLAC, where is your court order? She did not. She said she never investigated the AMLAC. When it has been established that there is probable cause that the deposits or investments are related to unlawful activities. What are these unlawful activities? Kidnapping, drug cases, hijacking. That is definitely not within the exception. Those are definitely not within the case. And so what did the Chief Justice do? Confronted with this situation, what did he do? He told everybody, I interpreted the law in accordance with the Foreign Currency Deposit Act. And he dared everybody. Hindi po ba pare-pareho ang interpretation natin yan? Isn't it? That's what he said. We all looked at it the same way. And he said, I will sign my waiver now, and I will prove to you that we all have the same interpretation. Let's open our accounts. Let's open our SAL-ends. Let's show it to the Filipino people that we have the same interpretation. Did anybody take up that challenge before the Honorable Court? Nobody. 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 Because the chief was able to show that his interpretation has been followed by most of the honest, hard-working public officials of our bureaucracy. There is no one witness here who testified that the Chief Justice accepted the bribe. There is none one witness here who said, ako po ang nagdeposito niyan kasi po may kapalit po na desisyon niyan. Not one. We are all surmising. They're saying, kaduda-duda yung movement ng pera. Napakalaki nung araw na to. Napakalaki nung ganun. Eh ba't hindi mo pinatunayan? Why did you not present the witness? We never decide cases based on doubt. We decide cases based on facts. That is how our system works. Now, yes, let me go to my last point. The prosecution says that the foreign currency deposit law is repugnant to the Constitution. My question is, can the Senate Impeachment Court declare the foreign currency deposit law unconstitutional? The Constitution is clear. Cases involving the constitutionality of any treaty, international executive agreement, or law shall be heard by the Supreme Court and bank. That is very clear. And isn't it the greatest height of contradiction if it is the Senate who will declare the product of its own work, the law that came from it, as contradictory to the Constitution? Galing po sa inyo yung batas. Umasa po ang mga kababayan. Tapos sasabihin nyo, hindi nyo pwedeng gamitin pag kayo ay nalitis. And even assuming that there is a tinge of unconstitutionality, the rule is decisions of this nature have prospective application. And let me read. The principle of prospectivity has also been applied to judicial decisions, which, although in themselves not laws, are nevertheless evidence of what the laws mean. The reason why under Article 8 of the new Civil Code, judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system. A compelling rationalization of the prospectivity principle of judicial decisions is the imperative necessity to take account of the actual existence of the statute prior to its nullification as an operative fact negating acceptance of a principle of absolute retroactive invalidity. If it is unconstitutional, you cannot apply it retroactively. That is a medication that the chief has already took. You cannot tell the medicine, do not take effect. The person has already drank it. It has already taken its effect. If it is against the Constitution, it should only be applied prospectively. In closing, let me just respond to Congressman Tupas's statement that the Chief Justice peddled his position for material gains. That is a lie. That is an absolute lie. The Supreme Court is a collegial body. He might be referring to the FASAP case. He might be referring to the TRO granted to former President Arroyo. But the court acts as an entity separate and distinct from the individual personalities of its members. Consistently with the intrinsic nature of a collegiate court, the individual members act not as such individuals, but only as a duly constituted courts. Their distinct individualities are lost in the majesty of their office. In re almacen. Do not blame the Chief Justice, Congressman Tupas. It was the Supreme Court who rendered that decision. And if you're relying on the dissenting opinion of the Honorable Chief Justice Sereno, let me just say that the dissenting opinion cannot be sustained. A dissenting opinion is not binding, as it is a mere expression of the individual view of a court who disagrees with the conclusion of the majority of the members thereof. That will be all, Your Honor.
George, the floor leader.
Continuation of the defense, Mr. President.
May I just be allowed, Your Honor, to carry on the
You have
discussion?
27 minutes and 36 seconds.
Nabawasan yata naman kayo. Thank you.